Dear students, welcome to EPG Pathshala. Today we would be learning about the acts which generally guide the development of the country, of our cities. So the learning objectives is about introduction to the acts and the various acts we will come to know or come to learn. So now, what is an act? As we all know, act is a legal mandate. An act, as I said, pertaining to urban planning and development is a legal mandate or a provision. And today we would be learning about the acts which pertain to planning and development. So the need of this act is it guides how to plan, to develop, to conserve, to regulate, to reform, and to formulate various organizations. So acts are required for all these purposes. We start with the Model Regional and Town Planning and Development Law of 1985, which was revised by Town and Country Planning Organization to enact a comprehensive urban and regional planning legislation in all the states and the union territories. And this model law provided 3 steps for the administration of this law. One is the preparation of existing land use map. Second is the preparation of an outline development plan and comprehensive development plan and their enforcement. Then preparation of detailed development schemes or redevelopment as envisaged in the plans and their implementation. Now, the broad provisions of this law was that of constituting the state, regional and town planning board by the state government for the purpose of advising on the delineation of the region for the planned development. The city has its region, we have already learned that, and the region has to be delineated. So one of the broad provisions of this law is about that. Then the directing the preparation of metropolitan, regional and area plans by the metropolitan, regional and area planning and development authorities. So the plans are made by the authorities at various levels. So this law directs or makes it a legal mandate for preparing of this law by the authorities, different authorities at various levels. Now, then setting up of metropolitan, region and area planning and development authorities for different urban and rural areas within the state to undertake preparation of development plans, to enforce and implement the plans, and to coordinate and the planning and implementation of the physical development programs. Basically the plans, as we said, I'll repeat, the plans are formulated by organizations. So the organizations are also formulated, or organizations come up based on acts. So those acts again also talk about how to prepare plans. So therefore the acts for these organizations as well as the work of these organizations, that is to prepare plans, are also formulated or based on certain acts. Now, based on the Model Regional and Town Planning and Development Law of 1985, many states enacted their town and country planning acts. Now, however, states like Haryana, Rajasthan and Union Territory of Chandigarh, Lakshadweep do not have town and country planning acts. Jharkhand, Chhattisgarh and Uttarakhand have adopted the parents state because these states have been bifurcated. So they have adopted the parent states town and country planning acts. And out of nearly 8,000 towns as per census 2011, to be precise about 7933 towns, nearly 2000, again to be precise 2032 towns have master plans. Out of that, that means nearly 20% have master plans. And not only that, out of that about 1500, that is 1483, are notified, and about nearly 550, that is 549 precisely, are under preparation. So we can see that we have a very handful. Most of these towns are not guided by any plan, and the city is developing and the towns are developing on their own. So we come to the 74th Constitutional Amendment Act of 1993, which is a very significant amendment to our constitution. And what was the amendment about? The amendment was to give powers to the urban local body. So the aim was to strengthen the urban local body which governs the cities and the towns through devolution of power. That means we just try to decentralize power. So therefore the urban local body have been given powers and about various functions have been assigned to them, and town planning or planning is one such function. It's the most important function which have been assigned to the urban local body, and this is a very important amendment to the constitution which has been done way back in 1993. And the objectives of this Amendment Act was to set up institutional mechanism to facilitate decentralization, then to activate the role of ULBs and specify their function. As I said, town planning is one of the functions, one of the 18 functions which the urban local body have to perform. Then to specify areas deemed as urban to include new urbanizing areas. Then to ensure representation of public, especially deprived the class and the women. Then to ensure that urban local bodies are not superseded. So this was an objective of the constitutional amendment. Very significant amendment to the constitution. Now, with this constitutional amendment, we see that a new structure emerges for administration. That is the District Planning Committee or the DPC, the Metropolitan Planning Committee or the MPC, and their jurisdictions are, as is self-explanatory, the jurisdiction for the District Planning Committee is the district. The Metropolitan Planning Committee, the jurisdiction of it is the metropolitan area or the metropolitan region. Then the municipalities, the jurisdiction is the municipal corporation boundary or the town boundary as we call. So this municipalities, there are three types of municipalities depending upon their size. The first is the municipal corporations for large urban areas. Then the second, municipal councils for smaller urban areas. Then we have the Nagar Panchayats for areas in transition from rural to urban. Then we have wards committee and other committee area within the towns or within the municipal corporations or in all municipalities with a population of 3 lakhs or more. Then we have area sabhas, which are 3 in each ward. So there is a hierarchy of administration which have been put forth through this very significant landmark constitutional amendment. Now, what are the responsibilities of DPC? What does it have to do? The DPC has to consolidate plan prepared by the panchayats and municipalities, because within a district there are various urban bodies, urban areas, rural areas, there are cities, there are towns, various different size classes of cities and towns are there within the same district. So the DPC tries to consolidate the plan which is prepared by panchayats for rural areas and municipalities for urban areas. Then to prepare the draft development plan considering economic development and social justice. So that is the purpose of plan, and the DPC prepares this plan with these as focus. Then to look after common interest between panchayats and municipalities, including spatial planning. Then the DPC also looks after sharing of water and physical resources, about integrating development of infrastructure, about availability of resources and finances. It also promotes integrated and participatory planning and recommends socio-economic district development plan, and therefore this district planning committee looks into the or it's an overarching body which tries to integrate the plans of both urban and rural into a consolidated whole. Now coming to the functions of the Metropolitan Planning Committee. Now the UDPFI, the Urban Development Plan Formulation and Implementation Guidelines of 1996, formulated by the Government of India, put forth the detailed functions of the Metropolitan Planning Committee, and which was to formulate development goals, objectives and policies, to formulate perspective plan within 5 years. So there was a time limit, a time stipulation, and also to formulate development plan within 2 years, and then to formulate the metropolitan area, that was an annual plan, and to consult professional organizations like the Confederation of Indian Industries or Federation of Chamber of Commerce and Industries for monitoring or to resolve conflicts. Now coming to the responsibilities of the urban local bodies, that is the town area or the city area, the jurisdiction of the urban local bodies. Now the 12th schedule said that, or it assigned 18 functions, as I mentioned earlier, 18 functions to ULBs, which were related to planning, infrastructure, public health, solid waste, fire service, environment, poverty alleviation, amenities, culture, education, aesthetics, etc. And therefore, as I said earlier, that urban planning, including town planning, became a prime function of the, or a responsibility of the urban local body, and also of land use, of construction of buildings, of planning for economic and social development, of roads and bridges, water supply for domestic, industrial and commercial purposes, then public health, sanitation, conservation and solid waste management, fire services, urban forestry, protection of the environment and promotion of ecological aspects. So basically it spoke about infrastructure provision, and it also spoke about the environmental protection, about planning, and also that means also about the sectors, various sectors, the urban local bodies have to go in detail. So therefore these sectors were identified, aspects were identified, and then also there are other responsibilities, that is safeguarding the interests of weaker sections of society, including the handicapped and the mentally retarded. Then about slum improvement and upgradation, because many of these cities had slums. So how to upgrade and how to improve. And therefore next is the urban poverty alleviation, then provision of urban amenities and facilities such as parks, gardens, playgrounds within the cities, and not only concentrated at one place but distributed. And then, so therefore, apart from uh, quantity, the quality of these facilities became important. Promotion of cultural, education, and aesthetic aspects. Then the burials and the burial grounds, cremations, cremation grounds, and electric crematoriums. Then the urban local bodies were have also have uh, within their purview about the cattle pounds, about prevention of cruelty to animals, then including and also about registration of births and deaths, and public amenities, providing public amenities like street lighting, parking lot, bus stops, public conveniences, and then regulation of slaughterhouses and tanneries. All this come under the jurisdiction or under the urban local bodies. So now we would be discussing the land laws. We start with the Land Acquisition Act of 1894, which of course has given way to the new act which is talking about, which is Land Acquisition, Rehabilitation and Resettlement Act, which came later. But let us start with the Land Acquisition Act of 1894. So, British government in India constituted the regulations to facilitate public acquisition of urban land from private owners, and the scope of the law was extended to other provinces in order to facilitate the operation of further infrastructure projects such as railway, tracks, etc. It harmonized and consolidated previous regulations into one single act applicable within the whole British India. And post-independence, Indian government continued with this act as a tool to purchase land at a lower price than that of the regular market. Now, the process of land acquisition was such, there are three main stages. One is about identification of the land parcel, second is about notifying the land parcel, and the third is about acquisition of the land parcel. So now the land identification of the land parcel, the highlights of this stage is that the land parcel, there's an identification of the parcel of the land only for public purpose. So that means lands were identified with the public purpose. Who was responsible for this? The district collector was responsible for this task. And if there was any objection, potential objection, that could have been done within 30 days. After that, the land was notified. There was an official declaration stating the public purpose. There was a public notice informing all parties, and 15 days after the notice, parties were supposed to present themselves to inform the district collector of their interests in the land and of the expected compensation. And the district collector subsequently inquired into the land area, its value, manifested interests of parties, amount of compensation, and potential objections. Then the land would be acquired. The stage of land acquisition, where the district collector decided all the terms and was supposed to inform all the parties, and rectification of all the clerical procedure was supposed to be completed within 6 months. There's a lot of criticisms of this act. Now, public purpose was undefined. What were the subheads of the public purpose? What was public purpose about? Then, amount of compensation sometimes was depreciated and was not as per what it should have been as per the situation or the context. Then government was dominating. There was use of muscle power, or the government was dominating. And the other party, the private owners, did not get a fair chance in many cases. There was delay in the process. the social cost of land acquisition was not considered. So now we come to the act which superseded this Land Acquisition Act, that is the Land Acquisition, Rehabilitation and the Resettlement Act of 2013, called as LARR. Now this new act repealed the Land Acquisition Act of 1894, and social impact assessment, that is SIA, and RNR, that is resettlement and rehabilitation, were integral parts of the land acquisition process. There was transparency and participatory approach at various stages of the land acquisition process, as well as the resettlement and rehabilitation processes. And there was this act ensured sustainable livelihood of the affected families, and about that consents have to be inbuilt to ensure participation of the affected families, and then about option of the lease to be explored and surrender of land possible if not used. There was dedicated authority for disposal of disputes, and there was no displacement before rehabilitation. So that means if there was displacement, then they have to be rehabilitated. People have to be rehabilitated. So people, and this act actually gave the right to fair compensation, and this act put people at the forefront. So it was, which was different from the Land Acquisition Act of 1894, where government dominated and the people were at the receiving end. If we see the timeline as defined in both the acts, we see that there has to be a social impact assessment study, and then which need to be appraised by expert group within 6 months. Then the preliminary notification has to be there within 2 months, and within the 1 year the publication of declaration needs to be there. Then within the next year the district collector has to work for the compensation, land compensation, and then for RNR compensation, and then the land would be taken over or acquired. This was in contrast with the Land Acquisition Act of 1894, where there was a preliminary notification, and within 2 months there had to be a social impact assessment study, then the publication of the declaration, then the award by the district collector, and then the land would be taken over. If we see the provisions, or if we compare the provisions of these two acts, we see that the latest act, that is LARR of 2013, had provisions for social impact assessments and its related studies, whereas the Land Acquisition Act had no provision for such. Then there was also a provision in the LARR for special provision for safeguards, food security, etc., whereas in the Land Acquisition Act there was no such provision. Then we find that regarding the publication of preliminary notification, in the Land Acquisition Act also it was there, but without the notification of the social impact assessment. Then regarding the publication of declaration and summary of the resettlement and rehabilitation schemes, we find that it is similar to the old act, that is Land Acquisition Act of 1894, except the rehabilitation and resettlement scheme, which was only part of the new act. And regarding the land acquiring, or the land, that is Land Acquisition Award, it is similar in both the cases. Regarding the power to take possession of land, also it was similar. For the State and National Monitoring Committee for Resettlement and Rehabilitation, it was included in the new act, whereas in the old act there were no such provisions. And for the R&R award, Resettlement and Rehabilitation Award, uh, which is already inbuilt into the new act, there was no such provisions in the old act. And finally, the establishment for Land Acquisition and Rehabilitation Authority, um, there was some similar provisions but not detailed out. Now, regarding the additional compensation in case of displacements, in the LARR Act there was provisions, whereas the old Act did not have any such provisions. Land Acquisition Act of 1894, as I stated, that the compensation was depreciated, whereas in the new Act it was rectified, and we find that 4 times the market value, the compensation which is equal to 4 times the market value is provided for lands acquired from rural areas, whereas twice the market value is provided for lands acquired in urban areas. After the land laws, we come to the main very significant the changes in the land laws. We come to the Environment Protection Act of 1986. Though we had various acts earlier protecting air quality, or talking about or that is air pollution, or talking about water pollution, which is resource oriented, this act, Environment Protection Act, focused on the interrelationships of all the resources, and that's why this is a very significant landmark act, because it said that environment includes water, air and land, and the interrelationship which exists among and between these resources, water, air and land, and human beings, other living creatures, plants, microorganisms and property. In fact, prior to this act, there was multiplicity of regulatory agencies in terms of managing pollution and protecting environment in India, and therefore an authority was required for studying, planning and implementing long-term requirements of environmental safety, and to give direction to and coordinate a system of speedy and adequate response to emergency situations which are threatening the environment. And thus this act was enacted, and there were amendments, and until 2008, the last amendment was till in 2008. There was a series of amendments, and the last was in 2008. Now, this, as I said, this was an overarching legislation, and which covered radioactive substances, disposal of radioactive substances, to use of plastic bags. That was the coverage of this act. And all the notifications, rules, regulations dealing with environmental protection were covered under this act. And this act provided for coordination and planning of nationwide programs for prevention, control and abatement of environmental pollution. It laid down the standards for environmental quality. It restricted certain areas to establish industries, laid down procedures for the prevention of accidents in such industries, and handling of hazardous substances. In fact, this act also spoke of developing the pollution control boards, that is Central Pollution Control Board, as an authority for overseeing and monitoring the pollution or looking into pollution control. And further, from this national body, we have the state pollution control boards also have been formulated. The objectives of this act was protection of the environment, improvement of the environment and prevention of hazards to human beings, other living creatures, plants and property. Now in 2008, as we said that there were many amendments, and in 2008 the last amendment. So therefore the objectives of this act with its amendments was to coordinate the role of government in relation to environmental protection and sustainable development, to provide a mechanism for the development of environmental policy and law, to promote a clean and healthy environment for all, to prevent and control and monitor and respond to pollution, to promote public awareness and involvement in environmental issues, and preservation of flora, fauna, and then to facilitate compliance and implementation of obligations under any regional and international environment or natural resource agreements or conventions, to facilitate sustainable development with respect to the management of the environment and natural resources, to facilitate the assessment and regulation of environmental impacts of certain activities, to promote conservation and, where appropriate, sustainable use of biological diversity and the protection and conservation of natural resources on the land, in air and in the sea, to reduce the production of wastes and to promote environmentally sound management and disposal of all wastes. So with this we come to the Disaster Management Act of 2005, and this Disaster Management Act, the objectives of this act was to formulate institutional mechanisms for drawing up and monitoring the implementation of disaster management plans, for ensuring measures by various wings of government for prevention of and mitigating effects of disasters, and for undertaking a holistic, coordinated and prompt response to any disaster. Now, why this act came in the first place? There is always a risk of disaster, which is a function of vulnerability and hazard, and if it goes unaddressed, then if disaster risk we don't mitigate or reduce, then disasters are likely to take place. And what does disasters mean? Disasters means catastrophe, mishap, calamity or grave occurrence in any area arising from natural or any man-made causes, by accident or by negligence, which result in substantial loss of life, of human suffering, or damage to and destruction of property, or damage to or degradation of environment, and is of such nature or magnitude as to be beyond the coping capacity of the community in the affected areas. So as I said that objectives of this, one of the objectives was to develop an institutional framework. So we see that at the central level, at various levels, an institutional frameworks were developed. At the central level, we have the National Disaster Management Authority, that is NDMA, which is more into policy making, and we have also the National Institute of Disaster Management, which is more into research. And NDMA is headed by the chairman of NDMA is the Prime Minister of a country. Then at the state level, we have the SDMAs, or the State Disaster Management Authorities. The chairman of those SDMAs are the CMs of those particular states, of the respective states. And then we have a National Executive Committee, that is NEC, for NDMA, related to NDMA. Here also at the state level we have the State Executive Committees, that is SEC, who coordinate and monitor the implementation of the national policy, the national plan and the state plans. So therefore the executive committee, while NDMA, SDMAs makes policies and the plans, the executive committee is in charge of execution. So therefore they coordinate and monitor the implementation of these plans at various levels, at the national level, at the state level. At the district level, we have the District Disaster Management Authority, who is headed by the district magistrate. Apart from the environmental aspects and the disaster management aspects, there is another sector in cities which needs to be looked into, that is about the shelter. It is about the slum areas, about informal housing. So we have a Slum Areas Improvement and Clearance Act of 1956, which was an act to provide for the improvement and clearance of slum areas in certain union territories and for the protection of tenants in such areas from eviction. Now, what is a slum? A slum is a condition or a situation where living conditions, where the basic quality of life is not maintained, people do not have facilities, they don't have basic amenities. So we have in cities, we have either slums which are notified slums, and we also have non-notified slums. So this so when we talk of slums, so we see that there are areas which are not notified as slums, but they have slum-like conditions, and it is inhabitable, non-habitable conditions. So the objective of this act, therefore, was to facilitate inclusive growth and slum-free cities, to provide assured security of tenure, basic amenities and affordable housing for slum dwellers, to assign a legal document of entitlement to every landless person in a slum area entitled to a dwelling space, to give mortgageable rights to alloters of dwelling space, and then to provide compensation for acquisition of land wherever necessary in the form of concessional buildings. The main problem with the slum is the security of tenure for people. They can be uprooted any day. So therefore, the legal document of entitlement is the patta, or the security of tenure, which was one of the objectives of this act, that people should get, or slum dwellers should get, or the city should look into their rights also as inclusive growth, as a part of inclusive growth. Related to this Slum Area Act, or related to this area of housing, or into the sector of housing, we have the Rent Control Act of 1958. It was an attempt by the Government of India to eliminate the exploitation of tenants by landlords, and this act tends to provide payment of fair rent to landlords and protection of tenants against eviction. And the objectives of this act is to protect the tenant from eviction from the house where he is living, except for defined reasons and on defined conditions, and to protect him from having to pay more than a fair standard or standard rent. Now, because of this act, there was a lot of problems which arose because of this act. There are areas in the city where the tenants give less rent and they cannot be evicted. So the buildings, the landowners or the landlords are not interested in maintaining these buildings and wait for it when it would come down, fall down, and the tenants do not want to improve or do not want to maintain because it's not their property. So ultimately this act brings in a lot of degraded areas in various parts of the city. Though there have been amendments, there have been amendments to this act to overcome these problems. Then we have again another act which is related to this, to the sectors, to the development, is the Real Estate Regulation and Development Act of 2016. And the need of this was that real estate and the housing sectors were highly unregulated sectors. There were lack of transparency in the projects, no proper information about the builders or the developers, and there were lack of remedies which were available to the buyers, and therefore this act came in. And this act actually tried to establish the Real Estate Regulatory Authority for regulation and promotion of the real estate sector. It also tried to ensure transparency in projects, protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal. It tries to provide proper information about the developer, and tries to protect the home buyers as well as help boost investments in the real estate industry. So the salient features of this act was that, as I mentioned, that it established the Real Estate Regulatory Authority at the state level. So it is a state real estate regulatory authority as the government body to be approached for redressal of grievances against any developer or builder, and it will happen once every state ratifies this act and establishes a state authority on the line set up in the law. And this law makes it mandatory for developers to post all information on issues such as the project plan, layout, government approvals, land title status, subcontractors to the project, completion schedule, all that with the state real estate regulatory authority. So it is supposed to be a transparent and accountable process. So this act tried to bring in that transparency and accountability in this whole process of real estate development, and also tried to regulate it. Now next we look into the industrial sector or the economic sector, how acts have brought in a change in the industrial sector. So now this industrial sector, we had the Special Economic Zone or SEZ Acts. Now SEZ, what are SEZs? SEZs are is a specifically delineated duty-free enclave and shall be deemed to be foreign territory for the purposes of trade operations and duties and tariffs. SEZs are an acknowledgement of the potential of export-led development strategy in accelerating economic growth. So this act was supposed to facilitate development of large areas which are identified as SEZs, and the objectives of this act was generation of additional economic activity, promotion of exports of goods and services, promotion of investment from domestic and foreign sources, creation of employment opportunities, and development of infrastructure facilities. So SEZs actually was facilitated to produce, as I said, that export-led development, and within the city, beyond the city, the special economic zones, the development of these special economic zones as foreign territory, it was promoted by this act, and it also had a lot of impacts on the city. So this act therefore becomes very significant for changing the spatial landscape of the cities and beyond the cities. Now we come to our heritage. We have a lot of heritage in our cities. Now which act talks of protection of our heritage? We see that there is an Ancient Monuments and Archaeological Sites and Remains Act of 1958, which is an act to provide for the preservation of ancient and historical monuments and archaeological sites and remains of national importance, for the regulation of archaeological excavations, and for the protection of sculptures, carvings, and other like objects. Now this extends to the whole of India, but construction of references to any law are not in force in the state of Jammu and Kashmir. Now, this act gives a legal mandate for protection of and conservation of our heritage, which would otherwise would have been overlooked and ignored, which in many cases it is done by through the process or in our process of development. So therefore, this act becomes a very significant act to conserve the heritage and protect the heritage while we progress towards the path of development. Urban areas are energy consuming entities, and energy is consumed for various purposes in the cities, towns, villages, and we see that there is an increased level of energy consumption. Sometimes we waste energy, sometimes it's inefficient energy usage. So this act, Energy Conservation Act of 2001, aims to reduce specific energy consumption in different sectors and sets up a specialized Bureau of Energy Efficiency to institutionalize energy efficiency measures, to monitor and measure at the macro level as well as the micro level. The objectives of this act is to provide for efficient use of energy and its conservation, and to provide a policy framework and direction to national energy conservation activities, to coordinate policies and programs on efficient use of energy with stakeholders, to establish systems and procedures to verify, measure, and monitor energy efficiency improvements, to leverage multilateral, bilateral, and private sector support to implement the Energy Conservation Act, and to demonstrate the energy efficiency delivery systems to public-private partnerships. Now, as we know that we consume energy, and this energy consumption is mainly sourced from the non-renewable energy sources. The energy which we use, we source it, they're mainly coal, petrol, diesel, LPG, kerosene, these forms, and the derivative of this is the power. All this is sourced from non-renewable energy sources. So this act actually tries to talk about how, because we know that they are finite, these non-renewable energy sources are finite, and some days, and it is very difficult to sustain these energy sources if we do not have efficiency of this usage. And as we all know, energy conserved is energy saved. So therefore, this act becomes very important in order to sustain our energy resources. Next, we come to the sector, what we were referring to as the informal sector, which contribute to the economy of our cities. And this Street Vendors Protection of Livelihood and Regulation of Street Vending Act of 2014 is the act which gives a legal mandate to protect the livelihood, to regulate this activity, and therefore under the purview of this act, all street vendors above 18 years of age is supposed to be granted a certificate of vending, with the transfer of certificate not being allowed. In case of a declaration of a specified area as a no vending zones, the vendors need to be relocated to another area, and all street vendors need to be accommodated in a designated vending zone. The certificates would stand cancelled if the vendor breaches the conditions of the certificate. And as mentioned above, that no vendor would be allowed to carry out vending activities in no vending zones. And the town vending committee, that is the TVC, has to conduct survey for all vendors under its jurisdiction every 5 years to know what is the number of vendors who are operating within their area, and a certificate has to be issued to them. Now, as I said, the town vending committee has to be there in each zone or ward of the local authority, and the local authority may physically have the power, in fact they have the powers of to physically remove the vendor and make seizure of goods of such vendors who have not relocated to the vending zones. And a vendor without a certificate would be penalized and would have to give a payment that may extend up to 2000 rupees. And there would be also a dispute resolution body consisting of a chairperson. He may be a civil judge, he or she may be a civil judge or a judicial magistrate, and two other professionals as prescribed by the government. So therefore, this act also becomes a very significant act, as I said, in order to regulate and monitor this activity which is pertaining to the informal sector. So dear students, today we have learnt about the various acts which are pertaining to the planning and development in our cities. The acts, whereas policies give us the guidelines, acts give us the legal mandate, and act in order to plan, develop, conserve, regulate, reform and formulate organizations in order to execute these acts. So we have learnt about land laws, we have learnt about Model Town and Planning Development Acts, we have learnt about Environmental Protection Act, we have learnt about Heritage Conservation Act, we have learnt about the SEZ Act, about the economic zones, we have learnt about informal sector, acts pertaining to informal sector, about the shelter aspects, that is the real estate and the slum clearance act. So various sectors, there are these acts which are pertaining to various sectors which are important for planning and development of the city. We have learned that. And why do we require the knowledge of these acts? Because when we plan within the purview of this act. These acts, as I said, it's a legal mandate. So we have to follow these acts. So as planners, when we plan for the city's planning and development, or when we have to guide the development and we have to plan for the city, we have to follow the acts. We have to see that what acts are there, and therefore the connect is there. We have to follow the acts and internalize the acts in our plans. Thank you.